Assalamualaikum warahmatullahi wabarakatuh. My name is Nikno Nazira Arisha Binti Nazman, and I will talk about case review about case Hanida Binti Long Lawan Pendakwa Raya. Citation of case. Hanida Binti Long Lawan Pendakwa Raya in 27 July of 2017 in Criminal High Court 4 in Kuala Lumpur and judged by Mat Ghani Abdullah. Facts of case. Appellant Hanida Binti Long was appointed as the Secretary General of the Corporate Banking Department, Mr. Ong Eng Bin, at OCBC Bank, who worked for approximately 6 years. Appellant only performed tasks such as setting appointment, handling Mr. Ong Eng Bin driver booking, assisting Relationship Manager RM in making expense claim, making photocopies, and preparing snack in the office. The issue of misappropriation of money was uncovered when someone, which is prosecution witness 4, found some suspicious claim made by the appellant. Further investigation by prosecution witness 4 found that the appellant had made 13 false claims by using his ID and password, which is ID and password Mr. Ong Eng Bin, in the Oracle system without his knowledge and permission. Issue of the case. First, whether the court can use its revisionary powers pursuant to the Chapter 31 of the Criminal Procedure Code or the Court of Justice Act 1964 to review sentences by the Session Court. Second, whether the court can and should interfere in the sentencing of the Session Court judge. And last one, what is the appropriate form of punishment against the appellant? First judgment of first question of or issue. First is both the Criminal Procedure Code Act and the Court of Justice Act 1964 clarify the power given to the High Court to check on the accuracy, validity, or decency of any sentences or order that has been recorded or passed, and on the ruling of any subordinate court proceeding. Section 35, Court of Judicature Act 1964, 35.1. In addition to the power conferred on the High Court by this or any written law, the High Court shall have the general supervisory and revisionary jurisdiction over all subordinate courts, and may in particular, but without prejudice to the generality of the foregoing provisions, if it appears desirable in the interest of justice, either of its own motion or at the instant of any party or person interested, at any stage in any matter or proceeding, whether civil or criminal, in any subordinate court, call for the record thereof, and may remove the same into the High Court, or may give to the subordinate court such directions as to further conduct of the same as justice may require. Second judgment for second issue. This court referred to the judgment of the case Datuk Sri Anwar Ibrahim version Public Prosecutor in 2002 in High Court 3, CLJ 457 at 494. It is at utmost important to stress here that the appellate court will not normally alter the sentence unless it is certified that the sentence passed by the lower court is manifestly inadequate or excessive or illegal or otherwise not a proper sentence having regard to all facts disclosed or that the court has clearly erred in applying correct principles in the assessment of sentence. Last judgment for the last issues. In determining what form of punishment inappropriate for appellant, this court often refers to a principle that clearly states in case PP versus Jafar bin Daud in 1981 as follows: sentence according to law means that the sentence must not only be within the ambit of the punishable section, but it also be assessed and pass accordance with established judicial principles. Commentary of the case. As I went through the case, I agreed with the judgment of the Session Court judge made by Judge Matgamni Abdullah, where he had taken the approach and consideration as well as the awareness that this offence was a serious offence. However, not in any the judgment, the session judge has emphasized the issue of public interest. In balancing the factor public interest and individual interest, and giving opportunity to the appellant, it is found that not a single sentence in judgment of the session judge take this issue into account. And indeed, the good name of the bank will be affected, which will lead a loss of public confidence in the bank. I also appreciate the approach taken by the judge, even though in the end the question arises where the prosecution raised the question of the sentence passed by the session court judge. The approach and the consideration of the public interest and appellant's right to speak has made me as a reader proud of the existence of a judge who has the discretionary and compassionate nature. That's all for me. Thank you.